Hi, everyone. It's Tina Ramirez, and thank you so much for joining me today. I am really thrilled because I have a very good friend with us today, Angela Wu Howard. And when I knew her, she was only Angela Wu. So if I slip up, you have to give me some grace, Angela. Um, but Angela is a leading human rights expert globally. I mean, when I first met Angela, she was a lawyer actually, she was the executive director at the Beckett Fund at the time. And she's now an international legal fellow at Beckett Law. And she has a doctorate in the philosophy of law and some very intricate things that she'll share with us today. But before that, she had a very distinguished career as a corporate lawyer, litigating hostile takeovers, I think it was, which she'll explain to us. So I'm going to let Angela share for us how she went from that into human rights law. But her human rights background has really been focused in particular on freedom of religion or belief for people around the world of all faiths. And much of what she's done at Beckett has been similar. And so I'm really thrilled to have her with us today and to be able to just share a lot about the work we've done around the world and that she's done domestically here in the United States as well, really protecting this freedom for everyone and protecting the law and the concept of freedom of religion or belief for everyone, as a legal concept across all faiths and belief systems. So Angela, thank you for being with me.
I'm really glad to be here. Thanks for having
me. A long introduction, and it will never do justice to all of the great things that you've done. So, all right, let's dive right in. Angela, you went from defending corporations to defending religious liberty. And I would just love for people to understand what motivates you to do this type of work and how your previous experience has really prepared you to defend people of diverse faiths.
So I was working at one of the big corporate law firms in New York City, Cleary Gottlieb, but I always had this interest in human rights work and civil liberties all through my education. And when I went to Cleary, one of the reasons I was interested in them is because they had a really robust pro bono practice where you could be doing pro bono work. So even while I was at Cleary, litigating hostile takeovers, I was doing quite a lot of refugee and asylum work and other human rights cases. So it wasn't that big of a leap. And I will say that working at a corporate law firm was a very different experience. But Cleary was a great training ground for just being a good lawyer. So a lot of those skills do transfer. And this is something I actually tell a lot of young people who ask about getting into public interest work, especially if they're emerging from law school with a lot of debt, that going to work for a corporate law firm, if you do it well and if you do it with integrity, there's nothing wrong with it. You can learn a lot of really great skills and also come to understand how public-private partnerships can work from a different perspective that can be really beneficial later on once you're in the public sector.
So tell me a little bit more about the transition and what led you to go into religious liberty work.
I had started thinking about moving entirely into the public sector, wasn't quite sure what I was going to do, and had already contemplated most likely going abroad, potentially, to The Hague or to some other international court or international system. And then I heard about the Beckett Fund, this little public interest law firm that only did religious freedom work and defended people of all faiths, from Amish, Christian, Jews, Muslims, Sikhs, Zoroastrians. So we sort of say A to Z. And I was really intrigued. And the job was as the international law director, overseeing a very small aspect of what they do, which is international law work in all over the world. And I really like this idea that we would be defending people of all faiths because it would keep us honest in terms of the principle of religious freedom for all. And I interviewed and got the job, and 2 weeks later, I was moving from New York City to Washington, D.C., which is sort of something I said I would never do, leave New York for another part of the country. I always thought that if I left New York, it would be to some other part of the world, but it really changed my life. I developed this incredible passion for religious freedom and not just human rights in general, and saw how so many aspects of human rights and civil rights kind of coalesce in the defense of religious freedom.
Well, and Angela, you, I think, are the one that I first heard this from. This phrase, religious liberty is really the canary in the coal mine. And when you see this freedom at risk, you often see so many other freedoms at risk. Do you want to share a little bit about that?
Yeah, so this is especially true, I think, in countries that don't have the sort of long history of religious freedom, or at least talking about in the public square the way the United States does. In many places and many jurisdictions, all you have to do really to see how robust a country's civil liberties is to look at their religious minorities and how they're treated and how much freedom that they have. And I think that once you see some of those freedoms eroding, it really is that canary in the coal mine. It's this early sign that things are not going well in many other respects. And the sort of, the flip side is true as well, that if you have a country with a robust defense of religious freedom and human rights for people of all, faiths and beliefs, and then you are very likely to see that the legal system functions for everybody else. So there's an interesting aspect to this, in the private sector for corporations and others that are interested in foreign investment in other countries. If their human rights system is working well, then you're much more likely to see that your contract is going to be honored if there's a dispute, for example. And I think that's kind of where the idea of the canary in the coal mine came from.
Well, it was brilliant. And so what year did you move to DC? Can you remind me?
I think it was 2005.
Okay. So I guess I moved there in 2004, and we connected at some point around then. And then when I went to work for Congress in 2007, you and I were on a panel together, I believe, at the United Nations related to the defamation of religion issue at the UN. And I just remember that we were both very passionately defending these ideas. Do you want to share a little bit about that that issue at the UN and what we did on that? Because most people probably don't know about it. And that was really, one of the most, prominent debates on freedom of religion or belief at the United Nations during that kind of time period.
So there was this concept of defamation of religion at the United Nations and a number of other international organizations that the OIC had introduced. And they were introducing these resolutions against defamation of religion year after year. Now, defamation of religion sounds bad. Defamation of anything sounds bad. So these resolutions were passing year after year. But when we started to look a little bit more closely about what they meant, we realized that it was really just a cover for these anti-blasphemy laws that were common in many of the OIC countries, like Pakistan and other countries, and Saudi Arabia. And the reason is because the notion of defamation of religion doesn't even quite make sense. Traditionally in law, defamation is against persons. You can't really have defamation of just an idea. And the way that you defend a claim against defamation is pretty much by saying what I said was true. It wasn't defamatory, right? So if you can imagine, in order to defend against a charge of defamation of religion or blasphemy, the way that you would have to go about it is essentially by asserting that what you have said about the religion is true. And if you think about that, it gets the government into the game of arbitrating what is and is not theologically true. So we very quickly realized that this concept was a way to kind of use international law as a cover for these blasphemy laws, which had been coming under a lot of pressure because they were so frequently abused. And religious minorities in countries that have anti-blasphemy laws yeah, are disproportionately impacted because they are frequently abused in just, even sometimes private disputes. People have private disputes, and instead they'll accuse you of blasphemy, and it's something really difficult to defend against, so you end up in jail. But the majority of people who are adversely affected by blasphemy laws in majority Muslim countries actually end up being Muslims. So there were many Muslims as well who opposed blasphemy laws and defamation of religion measures at the international organizations. And one of the things we were able to do was just to go door to door with the different missions at the United Nations and talk to ambassadors, talk to their chiefs of staff. We went door to door. We developed a white paper explaining the sort of legal aspects of defamation of religion, why it doesn't work as a concept, why it's difficult to enforce, why all of the things that people say to defend it really already, there are other laws in place that can, protect people from defamation, unjust defamation, and why it wasn't a workable concept. And within just a couple of years, we were able to flip the vote so that abstentions and no's outweighed yeses. And one of the reasons we even thought we could do this, even though there were, I think, quite a few sort of governments that normally are allied with the United States, and even the United States State Department itself, that said it wasn't really a vote that could be changed, is because we saw that there were quite a few typical sort of American allies in terms of freedom of religion that were voting yes. And it didn't really make sense because their domestic laws didn't reflect this. Their domestic laws really, defended freedom of religion. And we realized that it was actually just ignorance. And it was, in this sense, not pejoratively, but in the sense that these people, ambassadors, chiefs of staff, chiefs of all of these offices, are so busy that they hadn't had a chance to look into this. And once we were able to explain very simply the legal analysis, they very quickly changed their votes. And it was kind of remarkable to see that people were eager to learn, that they were eager to think in a sort of a little bit of a different way. And it was really great collaborating with you because you were working on the Hill and you had access to all of these, different people who had power and influence, and were able to get that machine rolling when we started essentially lobbying the United Nations country by country.
Well, it was a huge success because, I mean, these defamation resolutions have been promoted for a decade, and we're beginning to influence even the Durban process in these in other aspects and issues that were going on in the United Nations related to Durban. So they were trying to move this language into other parts of the United Nations, and by really cutting it off, we helped shift the conversation. And it leads me into something else, which is I remember during that time being on a panel with Asma Jahangir, who herself had been the UN Special Rapporteur on freedom of religion or belief. And I remember her saying that, even in her own, she was, I think, the head of the Supreme Court in Lahore at the time, that even when she would go into the bar and the court, because Pakistan, where she's from, really got very tense on this issue. And as we know, many people were imprisoned under blasphemy laws there, and just, it was basically you're imprisoned and accused, and you have to prove your innocence. It's not, innocent before guilt. It's you're guilty on accusation, and then there's no way of getting out of prison. And that's what happened to so many people in Pakistan. But I remember Asma Jahangir saying that she would go into the room after court with the different lawyers and judges, and that the situation had become so tense in Pakistan that you couldn't even make a joke, that people would just accuse you of blasphemy, that it had just become ridiculous. And so it really changed the climate of the legal culture across the country, where people were so afraid. And as you remember, Angela, 2 key leaders in Pakistan were murdered over their statements opposing the blasphemy laws in Pakistan. And so I remember working on a lot of that with you, but such an intense time. And I say that because we look at our society today and this attack on speech, and it's almost like we're in a similar, not the same, but a very similar climate where people are being attacked for things that they say and believe, and really protecting that freedom of conscience and thought in the public space is so critical for every other freedom. And that kind of goes back to what you said about the canary in the coal mine, that it really is a strong litmus test of freedom in a society. I don't know if you want to comment on that, but those are just some of my thoughts as you were sharing.
Yeah, you're bringing back a lot of memories. So, I mean, yeah, I sort of joke that I just parachuted in, right? I'm some American lawyer. I have a little bit of legal analysis to offer, but we really did over the years work with some true heroes who were in places that, I mean, they stayed even though they knew that their work would endanger their lives. And we have lost friends and colleagues over the years. I'm thinking particularly of
Shabazz Bati.
Bati and others, yeah. So one of the arguments against defamation of religion and blasphemy laws is that it really inhibits discourse and the development of thought, which is so crucial. I mean, in every realm, right? In philosophy and law, in science, that we have a free discourse and are able to disagree and even turn around and say, you know, you've convinced me that I'm wrong, or you'll never convince me that I'm wrong. I mean, it's just at the root of a robust civic society. And I think that people across the world, whether they live under blasphemy laws or not, know this.
Yeah. So let's turn to the trip we took to Bangladesh and India. Oh. Angela and I, so I used to often have Angela come and testify in the US Congress because she is so articulate and brilliant and understood these issues so well. And so one of the situations that her and I were watching closely was India. I'd actually been planning this trip for quite some time. We had friends that were monitoring it and said, look, the situation is getting more tense. We think there's going to be another attack on the Christian community in particular in this one state, but across the country, nationalism and extremism are on the rise. We need to do something. So they wanted me to do something about it in Congress. And I thought, well, I'm not going to go by myself. So somehow, Angela, you and I decided to go together. And I couldn't have chosen a better partner because I never would have understood the depth of and the complexities of just the issues that we addressed when we got there had you not been there. So we spent a month in not even like 1-star hotels because Angela traveled with her own sheet. And at one point I couldn't eat or drink anything because I was just purely sick. And Angela's stomach is like the stomach of steel. So that was Bangladesh and India for a month. And every once in a while we would get, high tea at a nice hotel, but for the most part, it was a pretty rough trip. And yet in the midst of that, I mean, we met a lot of people that were really suffering for their faith and from all different faiths and backgrounds. And it was remarkable to see that, but we were there specifically to figure out, okay, how can we address this and report back to help people better understand what's happening and understand how they can respond in a way that will shift the conversations in the country, but also, and understand the dangers of this nationalist fervor that was rising there, but also how can we help the people on the ground just report on what's happening? And sometimes in countries, that's the hardest thing. And it was great to have a lawyer there that you literally did, I don't even know what they're called, but you did the interviews with everyone and you briefed with them and you asked them questions, and it was so thorough that it really gave them a context for the types of details that are needed when they're going to actually litigate or prosecute any kinds of cases of persecution of their violations, of their human rights and fundamental freedoms. So can you share a little bit about, what motivated you to go and just, your experience from that?
I'm never going to forget it because I think it really solidified our relationship as well. And part of it was, as you say, because some of the conditions that we're traveling with were really challenging. And Tina was such a trooper. You didn't say this, but you got a horrible, horrible virus while you were there. And you were in such bad shape. And you never once complained. You just soldiered on. We kept with a pretty punishing schedule. You were, riding trains that weren't all that comfortable, and you just kept soldiering on. And I just admired that so much because it was it was evident to me that it was more, the mission was more important than your personal comfort, which, yeah, so I will never forget that. And we won't go into the details of that horrible car accident in Bangladesh either. But those are the kinds of, I think, adventures that make people sort of loyal to each other for life. And here we are talking about it many years later. We had a number of colleagues over the year in India that were educating us on, mostly it was anti-conversion laws from a legal perspective that were the challenge in various Indian states. And they were all at the state level. So you kind of had to fight them state by state. Now, there are a lot of countries that where you have sort of much more unstable governments, or you don't have a very sophisticated bar, right? That could use a lot of the kind of help that Hardwired does, where there is a lot of training on fundamentals, and then, you know, in more sophisticated legal systems, maybe more training with regard to religious freedom, why it's important, how you get into more of the details. India is not like that. India has a very sophisticated bar. So we were meeting with and working with lawyers who were seasoned, who understood the issues really well, but also had a ton of challenges in front of them and needed maybe a little bit more of an outside perspective, and also infusion of international support for the work that they were doing, because there was so much in the minority in their own countries. So I was super impressed with the people who were there, and that was a huge learning trip for us. So we did quite a lot of fact finding, but I feel like I walked out with so much more than we gave. It did so happen that while we were there, there was a huge communal riot and attack in the state of Orissa, which is one of the poorest states in India, in a region called Kandalmal. And the attacks are primarily against Dalit people, who are, you know, the lowest of the various historical castes in India. Many of the Dalits who were attacked were Christian. And I think that some of their, you know, conversion into Christianity over the years, and many of them had been Christians for generations, so they weren't new converts, but were really about what religion was able to offer them in terms of a narrative of their own inherent human dignity. But it's a very, very poor population. So while we were there, tragically, there was this communal violence, these riots that killed hundreds of people, over 100 people, in just the most horrific ways. Machete attacks, you know, one person was buried alive. And then, you know, tens of thousands of homes. I think it ended up being, you know, over 50,000 homes, very simple homes, but nevertheless homes that were leveled and destroyed in these attacks. And of course, thousands and thousands of people just displaced. So it was a really heartbreaking situation, but it did allow us to see very closely what happens in these situations, how difficult it is to do fact finding, how difficult the bureaucracy makes it to file any kind of cases against attackers, and how complex some of these issues are. So one sort of example is just that there are many tribal languages in India, and even translating into a language that the courts accepted required sophisticated translators who could speak several different languages or dialects. And that's something that required, you know, resources that people, oftentimes the most sophisticated advocates on the ground couldn't assist, because they weren't able to do the fact finding they needed just because of language barriers. So there are some really fundamental things, I think, that we realized were needed in situations like that we couldn't have anticipated. It wasn't just being a sophisticated lawyer, because India has very sophisticated lawyers. It wasn't even just the right national laws, because anti-conversion isn't written into the national law in India, it's at the state level. It was really sort of the fundamental things. And I think we took that back, and you were able to use all of those, that knowledge that you gained to start thinking about, you know, more effective aid when it came to international religious freedom assistance, and things like that. It was a really remarkable trip. We learned so much, and we met so many people who just are, I think, heroic in their day-to-day lives. I mean, Father Ajay Singh and Tamina Arora and all of her colleagues, yeah, just there every day working on some of these cases.
Well, and we really saw how important it was to understand the nature of the conflict and the violations so that we could articulate them more clearly within the US Congress and within the international arena so that people really understood what was happening. And a lot of people want to dismiss cases and issues there as, oh, this is just communal violence and mob violence, that there's no religious dimension, but there was a religious dimension. And of course, later that became more apparent. I mean, at the time they tried to blame the Swami's death. He was murdered, and that's what led to these riots on, I think, the Christian community. But then they later found out, no, it was actually these group of Maoists and others that had incited it and killed him. So it was really important to be there and to be able to dig down into the details, to know who you're looking to for that information when you're reporting on it back in your country, and looking at policy-wise, okay, what steps and actions do we take? So I came back and wrote legislation related to India and how we could address these anti-conversion laws, how the US could, in their bilateral relationship, engage with India in a more productive manner to actually address these laws, not ignore the religious dimension of conflict or the nationalist tendencies that were happening there, but really take them seriously and begin to navigate them in a way where they could help through diplomatically lead to greater respect for these fundamental freedoms for the people that are in India, that live them out every day. So I think there was a lot of great stuff that came out of it. And then, of course, what you're sharing is I think, led both you and I to think about the need for legal training, at all different levels in these countries, so that when you're navigating these things, not just, how do you understand the law? How do you understand how to file a case? But how do you understand the international legal system related to your own national or state system? And how can you apply it or use it? And how can you politically, navigate these things strategically? Like, what coalitions do you need? How do you do that part of it, which is often missed? And I think a lot of the other advocacy or interactions that happen in legal trainings in these countries, it's easy to give them a law or to say, well, this is what it means, but it's another thing to say, this is how you would use it. And that's where I think your corporate background and skill and understanding how to navigate hostile situations came in very handy. So I don't know if you want to add anything to that, and then I'd love to just, move to another topic. But
I fully agree that the complexity of these situations is more than, a headline or a meme can really capture. And that was really what's remarkable about being in place and talking to people who are close, and seeing it kind of firsthand, and realizing that there's a complex and layered history behind each one of these situations. The other thing that you said that kind of struck me was this sort of understanding religious freedom and the religious dimension in context. So, the socioeconomic situation of the Dalits, and is very much also tied up with their religious identities, and the kind of resentment that creates in the community when they choose to align themselves with minority faiths like Christianity and Islam in a Hindu majority country like India. And I think we also did meet a number of even high caste Hindus who were, I think, valiantly fighting against the majority tide to stand up for their brothers and sisters and minority faiths and minority communities. And I think seeing that really helped us to understand that, demonizing entire populations or oversimplifying situations would just make it so that you were really ineffective when it came to advocacy on the ground. And I think that one of the reasons why you were able to write effective legislation is because you were able to account for these details and show, an accurate knowledge and understanding of the situation, which I don't know that would have happened if we hadn't taken that somewhat extraordinary trip.
It was extraordinary. So then I ended up in Indonesia, and that was a whole nother situation, but it was there that these blasphemy laws that are in Pakistan have been spreading. And so there was a lot of violence against the Ahmadiyya community there, and of course the Christian community as well. And that led then to, I had written legislation in the US Congress to designate certain funds to the promotion of freedom of religion or belief within already designated funds within the Human Rights Office at the State Department. And so as part of that, then I engaged with the State Department and said, well, you need to promote like legal support and other things, as part of the positive promotion of this freedom. And so that then led to Freedom House and Beckett Law collaborating on a project in Indonesia, where you began to kind of establish this idea of a legal training institute. Do you want to talk a little bit about that?
I think that trip to India was at the kind of the root of this idea of a legal training institute that we collaborated on first with Freedom House. I mean, we saw that need, but I feel like you should speak more about it, because that's also was the genesis of Hardwired. So I'm this nerdy lawyer at this law firm seeing, oh, there's this need, and we could be helping advocates do more on the ground by training more advocates, and by also introducing elements of regional and international law that they might not know as much about. And I have this friend on the Hill who has also an education background. I mean, is it an MA in education, or you were educator for many years before you started being essentially a international advocate for the downtrodden. And we collaborated to develop this curriculum that I would never have been able to do, because it's not my expertise at all. And eventually, I think, you did work within Beckett for some time on that project, and then you sort of realized that you really needed to spin it off. It's not in the center of what law firms should be doing. And I mean, that's kind of how Hardwired was born.
Yeah, I mean, essentially, we had seen this need for many years. And even when I was at the US Commission on International Religious Freedom, I had, in my own time, just been inspired to write an educational program for teachers and students, and even foreign diplomats to be trained in, that help them understand this freedom. And so then when we were looking at all these issues on the ground, we just realized, we really need people to better understand the international legal framework that they can use to their advantage in these situations, and how to report accurately, how to respond well, to mitigate conflict, not exacerbate it. And it just seemed like there needed to be training. And I think Indonesia, you often shared, we were going in the court of law, and I mean, I don't know if you want to share, or you want me to, but you said, we went in to challenge the blasphemy law in Indonesia, and it's one thing to try to challenge it at the court of law, but if the court of public opinion isn't with you, it's very difficult to change anything, because the legal really follows the broader base of support. And so you can't effectively change anything at the court of law if at the ground level, everyone's just gonna, just be against it. So that was really the impetus for recognizing that you needed a top-down and a bottom-up approach, something where you could really help individuals embedded within the society understand how to articulate these values for freedom of religion, to build a base of support across the grassroots within their society and in key strategic places of influence, whether it's in law or education or civil society, journalism, et cetera, and really support them so that they could begin to navigate those challenges in their own country. And so so that eventually led to me developing the program, and then of course, creating Hardwired and using it within the organization. So it's, been amazing to share this, all over the world. And related to India, we do have a guidebook that we've created on the laws and on just strategic ways people on the ground can navigate some of those tensions and help alleviate suffering and persecution. So, and we've done those on a number of other countries. But back to you. So let's totally shift topics, Angela. I want to talk about your domestic work, because it's so important. And I really think it provided for me when I was at Beckett, such a just amazing framework and basis to understand international even. So let's just start briefly with Tanzin versus Tanvir. And can you give a little bit of context? 9/11, individual freedoms are being encroached upon, and you work for a law firm that began to address this case. So you can tell me a little bit about this case and why it was so important and timely. And we're doing this interview literally a week before the 9/11 anniversary, so it's timely. I know, of course, this will come out later, but I would just love for you to explain, because 20 years on since 9/11, this is still an issue today, this encroachments, and how important it is to how fragile freedom can really be, and how important it is to nurture it always.
Yeah, so Tanzin v. Tanvir, in the wake of September 11th, basically FBI agents approached a number of Muslim men. They were not involved in any kind of terrorist activity, nor were they suspected to be. And they essentially asked them to act as government spies in their own religious communities. And for leverage, the FBI threatened to put the men on the TSA's no-fly list. And the men refused, and the FBI followed through on their threat in 2013. But then in 2020, so just last year, the Supreme Court heard the case, and in a unanimous decision, I think a huge victory for religious freedom, ruled that the three men who brought the suit could legally sue under something called the Religious Freedom Restoration Act. And the Religious Freedom Restoration Act, it's really of sort of procedural interest because it doesn't say substantively how that case should go, but it imposes essentially a standard on courts hearing these cases so that they have to weigh the religious freedom of the people bringing the suit in a very strong way, and essentially recognize that only a truly compelling interest can overcome the kind of substantial burden that laws can impose on your average citizens bringing some of these suits. So that was really, really good. And I think it was a representative case of government overreach, and of how even national security considerations really shouldn't overcome our fundamental rights. And in this particular case, I just found it so egregious that our own government went after peaceful men participating peacefully in their religious communities, and wanted to use that as a way for them to kind of betray their own communities. And if you can imagine what would happen to these men if they had somehow buckled and hadn't had the courage to resist, and then didn't produce the kind of information, maybe because it's not there, that the state wanted them to produce. So suddenly their access to being able to travel in the United States, or even to leave the country on an airplane, would be under threat. It just seems so outrageous to me. And I thought that was a really important case in 2020, particularly because of the many government restrictions that we've seen, some of which I think could certainly be justified, and others, there hasn't even been an attempt to justify. So that's a summary of Tanzin and why it was an important case.
Can you explain a little bit more about RFRA, as it's referred to, the Religious Freedom Restoration Act? So what is the standard or the test that it uses? What does it say?
Well, if I could back up and sort of talk a little bit about where it came from. It actually emerged from a case called Employment Division v. Smith, which in legal circles is sort of famous. So Justice Scalia wrote for the court, a divided court in that case, and it involved two Native Americans who were denied unemployment benefits when they were fired from their jobs for smoking peyote, which at the time happened to be on the sort of forbidden narcotics list, but was used by their communities, by their Native American communities, as a sacramental substance. And it was used, the smoking of peyote was ritualistic. It wasn't used for any kind of sort of mind-altering effect, even though technically the chemical makeup of peyote could be used that way. But it was part of a religious ritual, not to, there's a sort of an analogy to the use of alcoholic wine in the Eucharist, in, say, the Catholic Church, in communion in the Catholic Church. And they brought their case all the way to the Supreme Court, and the court ruled against them. And primarily what they said was the legislature could grant them an exception to this law, which may very well be deserved, but it's not the place of the courts to even really examine whether or not their rights were violated. There was so much outcry against this decision, again, penned by one of the conservative justices with whom I actually have a lot of legal theory sympathy, so to speak, that Oregon State and even our national Congress immediately changed in the following 2 years their legislation to create an exemption for Native Americans. So in a way, Justice Scalia's sort of idea that legislature should take care of it was not completely incorrect. However, these plaintiffs happen to have some major momentum behind them in the legislative realm. And there are many religious minorities and just religious believers who wouldn't necessarily have that. And when they bring their cases to court, you want the standard to be broader than just the government has any rational basis for this law, so we're just going to allow it and not consider the importance of the right that's being violated. And what the Religious Freedom Restoration Act said was that a previous standard that the court had used in other cases needed to be applied in religious freedom claims going forward. And that standard is essentially that if there is a substantial burden, not just any inconvenience, but a substantial burden on a religious believer, then an incursion of the law imposing that burden could only be justified if the government satisfied two things. One, there had to be a compelling government interest. It can't just be something the government wants to do, but doesn't have a compelling reason to do. And the second element is that the restrictive law has to be drafted so that it uses something called the least restrictive means. That is, if there's another way for you to accomplish your purpose without burdening religious belief and practice and exercise, then you should take that route, which I think is actually really reasonable. You want laws to be written such that they accomplish compelling government interests with the least burden on any kind of fundamental constitutional principle as possible. That seems to me like just a very, one of the basics of sort of good rule writing, right? You don't want it to be overbroad. So the Religious Freedom Restoration Act protected that standard and essentially imposed it on the courts. It didn't decide the cases for the courts. Cases have been won and lost under the Religious Freedom Restoration Act, but it allowed religious believers to kind of have a very high bar for the government to satisfy. The case, or rather the legislation, RFRA has really benefited religious minorities. So if you just did a quantitative analysis of RFRA cases that have been brought over the years, a huge number of them have been on behalf of religious minorities. But some of the most famous cases, maybe because they just end up being more sort of like cultural lightning rods. Some of the best known ones are on behalf of Christians. But what people don't realize about RFRA is that it's been a huge protection for religious minorities all across the country.
And I'd love for you to share a little bit about Holt v. Hobbs and what that case was about. One of the things we often say is that religious liberty is so important, you can't even lose it while you're in prison. And this case exemplifies that, really, better than any. So tell me a little bit about the case, about RLUIPA, and then I'm going to share a little bit of fun kind of, story related to that, but
okay,
go for it.
So Holt v. Hobbs was a case that Beckett brought on behalf of Gregory Holt. He had converted to Islam at some point. He was he was known as Abdul Malik Muhammad, I believe. And his case went all the way up to the Supreme Court. So he was in the Arkansas Department of Corrections. He was a prisoner there for a violent crime. And we undertook his case when he was not permitted by the Arkansas Department of Corrections to grow his beard, which, as a devout Muslim, he believed that his faith obliged him to grow this beard. What was very interesting was that the Arkansas policy did not actually prohibit inmates to grow any beards. There were already exceptions for medical reasons, for example. So there are men who have certain skin conditions that make it not healthy for them to shave on a regular basis, and much better for them to grow beards. And across our correction system in the United States, something like 40 something systems have these kinds of exceptions for medical and religious beards. So it had been shown across prison systems in America that you could do it without really endangering any kind of security considerations. And it was security considerations, much like in Tanzin, that the Arkansas Department of Corrections used as the excuse to not allow him to grow a beard. And what he wanted was actually just, I think, a 1/4 inch beard. So it wasn't anything that you could, I don't know, hide a razor in, or it didn't pose any danger to the community or to the guards, essentially. So his case was litigated all the way to the Supreme Court, and it's a case that Beckett won unanimously, which I thought was really extraordinary. And it set the tone for cases in prisons to basically say that whoever you are, you still have your humanity, you still have your fundamental freedoms, and it's really important that even if you are a prisoner, even if you have made some egregious mistakes in your life, you are a human being first, and that one of the fundamental ways that we know that people are able to express their humanity is through religious belief and exploring that instinct, and thinking through questions of what is true and what is not, and thinking through existential questions that religion often sort of prompts. So we're really proud of that case.
So can you tell me a little bit more about RLUIPA and how that came into the case? What is RLUIPA?
So RLUIPA is called the Religious Land Use and Institutionalized Persons Act, and it followed on the heels of RFRA, the Religious Freedom Restoration Act, which we just talked about. And the idea was that that many religious freedom issues were coming up with zoning laws, and in institutions, particularly in prisons. So Beckett has also had cases having to do with access to kosher or halal meals in prisons, to whether or not religiously based ministries can operate in prisons, for things like Bible studies or other kinds of trainings on level with secular, and the participation is always voluntary, but with secular programs. So it just focuses on institutions and on land use. Maybe my favorite story having to do with land use involved, this is a very old Beckett case. I don't know whether I can remember all the details, but it involved a small Buddhist monastery that happened to be in a mostly residential area. And they were kind of asked to rezone for their continued practice. And one of the complaints of the neighbors was, I think they just kind of threw everything in that they could think of. So it's not just the usual, if it's a Sunday and there's a church being held in this place, there's going to be tons of parking and all of this kind of disruption. But one of their complaints that they threw in was sound disturbance. But it was a Zen monastery that practiced primarily silent meditation. So it was kind of one of the tells in this case that we could demonstrate to the county authorities and to the courts that what was really behind some of the animosity to the Buddhist monastery being there was really discrimination and prejudice, and not just these basic concerns of having a peaceful neighborhood.
Well, I remember when I was in college, I would visit Cottonwood Christian Center that that I didn't even realize at the time, obviously, because I didn't know about Beckett, but that was another case that you guys took up because they were going to have their land taken from them and rezoning ordinances in the city out in, I think it was Cypress, California, and the city was going to build a Costco over them. And I love Costco. Everybody knows me. I love Costco, but, I don't believe Costco has a right to take a church's land and use it, for food. So I think it was that was always an interesting case. And that was my first kind of experience. I remember being in the church where they were talking about this case that they were going through and how the local government was trying to take away this land, saying, well, you can't build on it. We're going to use it for a Costco. And it's like, well, why? You can't just rezone it and put a Costco there. So anyway.
Yeah, so a corporate interest too butt up in these cases quite often. So Beckett's had a number of cases having to do with Native American land that is sacred to Native Americans. And there are various sort of governmental and corporate interests that come in, and it's a huge fight. I mean, it's usually we're really representing people who don't have a lot of I think power in the system. And these pieces of legislation like RFRA and the Religious Land Use and Institutionalized Persons Act have been really crucial in their ability to make sure that they're heard and that they can defend their sacred lands.
So let's shift a little bit, Angela, and talk about some of the cases that have come up in recent years related to government overreach, particularly in the health care world. So Little Sisters of the Poor versus the Czar, back in 2011, Health and Human Services issued a mandate that required employers to provide contraceptives and abortifacient insurance plans. And this violated the deeply held beliefs of Little Sisters of the Poor, which you can tell us more about. So can you just tell us a little bit more about what Little Sisters of the Poor's response was, why it was particularly challenging for them as a Catholic order of nuns who mostly care for elderly people when it was decided, and a little about the implications on other cases that we've seen, like Hobby Lobby.
Yeah, so the Little Sisters of the Poor is, as you said, an order of Catholic sisters, religious sisters, and they work with the elderly poor. So if you've ever been in one of their homes, they're beautiful homes that have a lot of medical services and create a community for the elderly poor who have no place else to go. But I've been so impressed by the Little Sisters themselves, who just have a calling and have dedicated their entire lives to serving the elderly poor. And along comes the Affordable Care Act, which, it's been very divisive in our country. There are people who think it's done really wonderful things, other people who think it's created lots of problems. I'm only going to speak to one aspect of it, and that is its impact on religious freedom and on citizens like Little Sisters of the Poor. In terms of the contraceptive mandate, as it's known. So the Affordable Care Act required that every FDA approved contraceptive needed to be carried in every insurance plan. And this was a bit unusual because it wasn't the case for many other areas of health. So for example, with Parkinson's or MS or any number of other diseases, insurance plans were not obligated to cover every available treatment or medication. It was really only in contraception, or that was one of the few areas where you had this. And different people objected to covering contraceptions for various reasons. And so the Little Sisters of the Poor object to contraception, artificial means of contraception, by conscience. It wasn't something that they felt that they could support. And so they wanted an exception. And the legislation had no exceptions written to it that would cover them. So there were a number of exceptions. There are exceptions. I mean, the Affordable Care Act is replete for exceptions. There were exceptions to coverage for any employer that had fewer than 50 employees. There were exceptions for, PepsiCo and Exxon because of their grandfathered plans, and the reasoning behind it was essentially economic. But the religious exceptions covered employers like churches themselves, but not religious orders, not parachurch organizations, essentially not the arms and feet of the church that do so much in the public square in terms of medical care, in terms of social work. And Little Sisters got swept up in this. I mean, they were living kind of very quiet, servant-oriented lives before this. But when threatened with massive fines that would essentially cripple their entire ministry if they did not abide by the Affordable Care Act, they decided that their consciences wouldn't allow them not to fight back. So the government wanted them essentially to sign a piece of paper enabling their insurance companies to work with the government to provide this coverage. And this visual has always been so compelling to me. And the government went and said, look, how does it violate your conscience to sign a piece of authorization? Just sign your names, just sign it. And the Little Sisters wouldn't do it. And I found this such a compelling kind of sketch of these religious sisters who, because of their fundamental faith in God and where they thought that life began, they wouldn't sign their names. They wouldn't sign their names. And, and the government itself said, well, this shouldn't even really matter. Well, if it doesn't matter, then why do you want them to sign, right? And that sort of almost tells you how deep of a violation of conscience some of these cases really reach, that's really what it's about. It's not just about the provision of contraception. So we'll get to maybe Hobby Lobby later. That's another case involving I'll tie them together, if you will, but that's another case involving a privately held, so family owned corporation, Hobby Lobby. They have kind of craft supply stores all over the country. And it was a Christian family that owned it, and they objected to only 4 of, something like 21 FDA approved contraceptives because they were abortifacient. That is, that they could prevent fertilized cells and embryos from attaching to the uterine wall, and therefore prevent, growth of the fetus and eventually of the baby. And various mechanisms like that. So they were willing to provide all of the other contraceptives, but not those 4. And that case was somewhat different because it had to do with the rights of privately held corporations and whether or not groups of people, when formed into corporations, had any right to express themselves in a religious manner. But it's similar in the sense that you have all of these exceptions created for economic reasons. But the government is suddenly saying, if your reason is religious, then there's no other way for us to provide contraception other than involving you in violating your own religious conscience. So Little Sisters looked at this and they were basically willing to take a stand. And at the end of the day, they have had to return to the Supreme Court multiple times, even after they won against the Obama administration at the national level. States in recent years have taken them to court at the state level. And the Supreme Court has essentially repeatedly sided with them, sometimes unanimously, in essentially saying you can't make them sign that piece of paper. And a really fundamental aspect of this kind of goes back to RFRA, right? So RFRA wasn't implicated in every case against the Affordable Care Act, but that principle that the government should really be using the least restrictive means has been implicated. And the facts are that there are 1,000,001 ways that the US government and states can provide free contraception to women without involving nuns who have an objection to it. And that's essentially what the Supreme Court has said over and over again. You can give it out for free. You don't have to go through people who don't want to participate because they think that that kind of participation implicates them in a morally wrong act. And I think we don't have to agree with the Little Sisters about whether or not using artificial contraception is a violation of any kind, a moral violation, in order to understand how very important it is that we preserve the ability for them to conscientiously object to participating in acts that violate their conscience.
Well, and this goes, I mean, we've seen this in all the different cases we've been talking about, but this government overreach and navigating this sense of why is religious belief off limits to government? I mean, what is it about it? Because I think a lot of people ask that question today. And not only that, but in the Little Sisters case, I mean, they were fined. They were threatened with, thousands of dollars in fines for just saying, look, I can't violate my conscience. Why is that so fundamental? Can you help people understand that a little bit?
I think it's actually just a misunderstanding of the role of religion in public life and even in our founding. Yeah, I mean, I think that we live in an age where people think that this idea of separation of church and state means that religion doesn't belong in the public square at all, and that you should never hear about it, or that if you hear about it, it should only be the parts that, are easy for everybody to swallow, and there shouldn't really be dissent involved. And that's just wrong. So I think that it really just has to do with a misunderstanding of what we think a robust civic square looks like, and even of our own Constitution. So I think that some of our most fundamental principles have to do with a robust participation for everybody, and that makes for a better country. That makes for I think that makes for better discourse. It's going to lead to a more accurate understanding of the subjects of rules and laws, the people and their actions, and that kind of conversation is only going to make it so that our lawmakers and our policymakers do their jobs better. And if you shut those voices of conscience out, you miss a whole number of things. So you can't really separate what the Little Sisters do in terms of sacrificing their entire lives for the elderly poor from the context of their conscience and what drives them from this faith in God. And to sort of say, let's take the benefit of the sacrifice you're willing to make for this population that the rest of society under cares for, and ignore what drives it, and even just make it so that can't be a reason for any of your actions, is really a lie. I mean, it fundamentally ignores a huge part of what makes the Little Sisters the Little Sisters.
That's perfect. Thank you, Angela. Okay, let's talk about Hosanna Tabor. So when I first came over to Beckett, you were in the middle of the Hosanna Tabor case. And this was really fascinating because I think it's had implications ever since then. I mean, it's just, what is the, can religious groups discriminate, and where is the line drawn? So tell me a little bit about this case.
Oh, this is such a fascinating case. And Hosanna Tabor, a Lutheran church and school that and a teacher at their school that had been commissioned or called essentially as a religious minister in her teaching job. So the school had sort of two kinds of teachers who were professed Lutherans, who went through theological training, and then were called by the congregation to serve at the school as a teacher. And then they had sort of contract teachers, if you will, who didn't have to be Lutheran and weren't called theologically, and they didn't necessarily undergo any kind of theological training. They were just, brought in to teach a math class, for example. And in this case, the teacher became ill, and she was not able to teach for some period of time. Now, the church and the school kind of saved her spot, so to speak, for quite some time, until eventually they had to hire a substitute teacher to come in. At which point she essentially tried to get her job back, saying that she medically could return immediately, even though there had been no indication of it before. And eventually sued. First, she threatened to sue, which violated the congregation's own sort of ethic of trying to resolve these kinds of disputes internally first, and trying to talk through civil disputes in more of a religious context. And she was eventually fired for that. And then she brought her case all the way up to the Supreme Court with the help of the Equal Employment Opportunity Commission, which is a federal agency that does, employment-related cases. And the case was the first case that the Supreme Court heard that implicated something called the ministerial exception, which had been accepted in all the lower courts prior, but had never been tested at the Supreme Court. And the ministerial exception essentially says that you can't bring employment discrimination suits in cases that involve religious ministers. So we think of religious ministers oftentimes as ministers, pastors, imams, rabbis, right? And this case was primarily testing the ministerial exception at all, whether or not the government can use discrimination or any other kind of law to come in and tell a congregation that you have to fire this rabbi or you have to hire this imam and not that imam. And you can imagine that's just really dangerous territory for the state to be getting involved in the position where they can tell you who your religious leaders that teach your congregation or that teach your religious community theology and other things is. Now, the teacher that was implicated in Hosanna Tabor happened to also teach religion classes along with other academic subjects. And she did sometimes lead student chapel, school chapel. So it wasn't as though she wasn't teaching religion of any kind. And in this case, the Supreme Court ended up deciding 9-0 in favor of the school. The one interesting detail is that the school, by the time her case reached the Supreme Court, she had brought a case under the Americans with Disabilities Act because she had had this illness and which might have been considered a disability. And but the school had satisfied all the substantive provisions of the ADA. That is, the church and the school had accommodated her to such an extent that by the time she got to the Supreme Court, she didn't have any of those claims. She couldn't say that the school had not reasonably accommodated her disability. The only thing that was left was something called the retaliation provision. So the idea is that an employer can't retaliate against you for bringing a lawsuit, which I think is a really fantastic provision, but it meets up against this ministerial exception in the question of whether or not you really want to impose a religion teacher on a religion school. So that case was incredibly important. And there have been, Our Lady of Guadalupe was another case that Beckett brought and won at the Supreme Court, which is a huge victory, also just working out the ministerial exception and where it would and would not apply. But the crazy thing about Hosanna Tabor is that it was one of the I think it's possibly the most important religious freedom case in the United States of the last century. And I do primarily international law. It's really all the credit goes to my colleagues who focus on domestic law, but we have this great picture of them walking out of the Supreme Court and it's just empty. So there's nobody on the steps, and the building is imposing with these vast steps. And all to say that it was a pretty under the radar case. Nobody was paying attention to it. And then when it came to Little Sisters and Hobby Lobby, there were protesters and media, and it was an absolute circus. And these questions of whether or not religious communities can decide how they live peacefully, how they live within themselves, has become hugely controversial in a way that it wasn't just, less than 2 decades ago.
Yeah, it's fascinating. And then I think that this, the kind of the final topic I want to talk about really kind of epitomizes that. So last year, we had a pandemic, and in the midst of the pandemic, a lot of states began to overly restrict religious worship in ways that was disproportionate, that was excessive, that was just, ludicrous, really. And in my mind, as I watched this kind of unfold across the country, we saw so many different cases and instances that went to court. You saw this, this cultural attitude that it was okay to shut down churches and to stifle religious worship and to treat it kind of like we saw in the Hosanna Tabor case, where the Obama administration argued that religious groups are no different than an Elks Club or, some other kind of hunting club, that they tried to make the case that they were no different, they should be restricted the same. And so what happened last year during the pandemic with restrictions on churches and a particular case in New York related to that? Can you talk a little bit about that?
Well, I mean, I'm not even sure that they were saying that religious groups and churches and communities needed to be restricted in the same way. This
Well,
is just
exactly. It was kind of a different, right? Yes.
so what I mean, we brought a number of cases, particularly in New York, but in other jurisdictions as well, and against Governor Cuomo, that involved, Catholic diocese in New York City, but also, a Jewish girls' school that had been that the state had and the city had tried to shut down. And what we discovered when we just did a little bit of research into why was that there was almost no reason. So there's no disputing that public health is a huge consideration. That's right there. That's a compelling government interest, right? If we're going to keep going back to the standard of our LUPA. But even any restriction, I think, even outside of the religious context, you want sufficient justification for it. And that's what was really extraordinary about some of what we saw last year in terms of defending religious clients, was that sometimes there was no justification whatsoever. So one of the things we did was look at Governor Cuomo's sort of own map for how he would decide which zones were in the red zones, and that is should face the highest restrictions and lockdowns. And they look like targets on his map, but these red zones mapped right on top of Orthodox Jewish communities. And, I've heard people sort of say, well, the numbers were up in the Orthodox Jewish communities. It's just a coincidence. But it wasn't, because then once we looked at hospitalization rates or case positive rates, or there was almost no difference in these communities with other places. So it really did end up visually looking like religious targeting using his own materials. We also had a recording of him talking on a community call with a number of rabbis in the community, essentially admitting that there wasn't a lot of science behind the restrictions, but people were fearful and he had to respond to that. Well, that's not enough justification to shut down religious services and prevent people from gathering. So these are the kinds of things that we were seeing and were able to litigate successfully in order to have those restrictions lifted. So the question isn't all or nothing in the sense that, can government ever impose restrictions in the name of public health? Absolutely, there are those circumstances, right? The question is whether or not they're justified, and also whether or not that justification is taking into account really fundamental liberties. So our cases were very, very fact intensive and specific to those situations. It wasn't a blanket claim of, religious communities can do whatever they want, regardless of compelling government interests. It was, do those compelling government interests actually even meet what they say? That do the means being used even meet those compelling government interests? Are they justified enough to encroach on these fundamental rights? And I think of, some of the really heroic things that people in religious communities have done. There are a lot of Dominican friars in New York City who were chaplains in hospitals, and they never once stopped, even without, enough PPE, like other healthcare workers who also heroically showed up every day. They were there at the last rites. And I think people miss how deeply important those aspects of life and the access to our spiritual selves are, especially in a crisis. It helps us, I think, to remember why we make some of the sacrifices that we have. It helps us to kind of recall our humanity. And it also helps us to sort of ask a question that I think has been a real challenge for the country, which is, what is the exit strategy on these restrictions? Is there a metric that we're using to gain back some of those fundamental rights, to gain back different freedoms? Why are we thinking in terms of gaining them back rather than having the government bear the burden of really sort of justifying that certain measures actually work for containment? And I think that religious people who are willing to do extraordinary things help us not to forget those fundamentals. I know of a parish of a priest here in Phoenix when the county locked down in mid-March. He was performing, 10 masses a day so that people could come in smaller groups and social distance and still have access to the mass. And I think of him as somebody who had a particular calling, who had a lot of respect for, public health concerns, but also knew that we shouldn't be giving up sort of, fundamental parts of who we are. And that I know that congregation pretty intimately, and there, really haven't been any major outbreaks throughout the year. But I'm grateful for people who just kind of keep turning us back to our humanity in that respect.
Yeah, I think that's, a perfect way of summarizing it. And, one of the things in this case and in many of the cases that happened last year was that these religious communities were actually being treated less than like a grocery store or another place where people go for sustenance. And to many people, their place of worship is their sustenance. It is their hope in these times of crisis. You don't shut it off. And that's why those laws that we talked about being narrowly tailored and having a compelling state interest are so critical. And I think you said it really well, Angela, when you said, the burden isn't on us to prove our rights. It's on the government to prove why they need to actually limit or restrict them in any way. And that's really fundamentally what it needs to come down to. And that's, of all the cases we're looking at, and we've seen overseas, and we're looking at international cases, frantic, rushed laws that are vague are always bad laws. And so, we just want to be very careful with our freedom, and this in particular. And so understanding and recognizing these things is so critical to approaching these things in the future, these kinds of cases. I've met with so many young people and students that think that it's okay to just, take away the rights because it sounds okay, or it sounds like maybe somebody would be offended or hurt. And it really denigrates the value of the right and of, I think, religious worship in particular. So.
Well, this is full circle because when we started talking about the defamation of religion at the UN and in other jurisdictions. And that was really about whether you could protect people from being offended or hearing claims of religious truth that they didn't agree with.
Mm-hmm.
And I think the answer absolutely has to be a resounding no. And I don't think that can be maintained unless we protect the ability for people to function in the public square and to have that voice in everyday life. And all of these, these religious communities, whether it's a Christian family that owns a corporation that serves all of these employees, or whether it's religious sisters, or whether it's a group of Muslims in a prison that's meeting weekly for Friday prayers. They offer something that I think we often do forget. They even if they don't agree with each other about who God is, Beckett's founder Seamus Hassan always said that religious freedom isn't about who God is, it's about who we are. So we don't have to agree about who God is or these theological claims to sort of say, what makes us human is fundamental access to exploring our consciences and acting thereby in a peaceful way. But these religious communities often do set examples that you don't see elsewhere. So Hobby Lobby is kind of an interesting example of that. They're actually an incredibly good social citizen in the sense that they pay all of their workers, their salaried workers get paid much higher than the minimum wage, that they have excellent health care. The government came in and said, well, if you don't want to include these 4 abortifacient deficients in your healthcare plan, just don't provide health insurance and pay the fine. And actually, the federally imposed fine will cost you less than maintaining your healthcare plan. And they refused, even though it would have saved them money, because they said, look, we have employees who are pregnant. We have employees who are battling cancer. We're not cutting them off from their healthcare providers by doing it this way. It's not just about money. And I think these cases also really show us when what the government claims it's doing isn't what it's actually doing. So in that case, it wasn't about healthcare because they could have provided the contraceptions and abortifacients in other ways. It was really about coercion. It was really about, you have to agree with us and get on board with a certain type of thinking or ideology, or we're not going to let you go, even if we're willing to make exceptions for Exxon and Pepsi for economic, corporate interests. So I think that we underestimate how much it is that religious communities really are a very particular kind of voice in their communities, and remind us of values that are kind of easy to forget. And this is again, full circle, goes back to this idea of the community in the coal mine. I mean, the strength of your faith in these fundamental freedoms only goes as far as how willing you are able and willing to go to defend them for people you most disagree with.
Yeah, I think that's a great way of ending it. Angela, thank you.
It was really nice talking to you. It's been a while.